ahead.
My, well, my my question was that, so for example, they are pregnant for 4 months and then something happened and they have to be on bed rest for a month. And then they finish that month and then they return back to
They
work.
return, yeah. So that
Right. So
part can be treated as maternity leave, yes. That's
also
why I said the
so you would
period
deduct that
or
1 month.
period.
You would deduct
Yeah,
what that 1 month, and at the end of
yeah,
when they have baby, they only entitled
yeah,
to 2 months.
yeah, yeah.
Okay. All
But
right. Thank you
I'm
for that.
guarded when I say 2 months because it's not all of it would be with pay. Okay.
Right.
So I'm gonna ask a question while I have you, Karen. Is there a difference between maternity leave and maternity leave with pay?
Maternity. Yes. Yeah, maternity leave. Like, all right, for example, what I know about the law, for the first 2 months, you get pay with for the first 2 months. So even though they're changing it now, and then for the
No. Nobody has changed anything.
well, they are in the process of changing.
They are not in the process of changing anything.
But the third month is usually without pay.
All right. So you see, a lot of people hear a lot of things and get confused. All right. So first of all, let me start by saying that the Maternity Leave Act is not presently being reviewed. It is something that is being talked about, but I am reliably informing you that that has not commenced.
Okay.
If you hear it anywhere else, tell Ms. Caroda say it's not true.
Okay.
Okay. All right. The second thing I want to say is that maternity leave is a period of absence due to pregnancy or confinement. So therefore, if somebody just start working with you and they're pregnant, they are not, quote unquote, qualified for maternity leave with pay, they will still qualify for the time away because you can't tell a baby to hold on until they qualify. The baby is going to born, not true?
Okay.
So in that case, the person will get the time away from work, and that is called maternity leave. There are a couple of things that qualify the person now for not just the maternity leave, but the leave to be given with pay. And that is what we're going to be speaking about for most of this session. All right, so my second slide on that says maternity leave should not exceed 12 weeks of each pregnancy or confinement. So even if the person has twins, is 12 weeks same way. You don't get 2 times because you have 2 babies. Or if you have triplets, you get 3 times because you have 3 babies. No. Each pregnancy is treated as one instance, okay? And for that one instance, the person can take up to 12 weeks leave normally. What it means though, is that if that person, for instance, a woman may have difficult pregnancies or do a cesarean section or something of that nature that requires them a little bit more recovery time. And what the law says is that there can be an extension of up to 14 weeks, right? What do I mean? It is not 14 additional weeks. It means that the entire absence cannot, under any circumstance under this act, exceed 14 weeks. So if the baby is sick or the mother is sick, then the additional 2 weeks can be added on, and that has to be with the medical practitioner's instruction. So it's not like, well, so I feel like I want 2 more weeks. No, that's not how it works. It has to be with the medical practitioner's instruction by a medical certificate. All right, so when we talk about confinement, and this is the question I would have given you at the start of the session, it is the birth of a living child or the birth of a child, whether living or dead, after 28 weeks of pregnancy. And it says after 28 weeks in the law. So what it means is that from the 29th week onwards, the person qualifies for that maternity leave with pay if they have done the other qualifying period of being in the organization for at least a year, right? 52 weeks, right? So the 29 weeks, somebody works out to say it's 7 months that they're talking about. And therefore, if the person has a miscarriage before the end of 28 weeks, they would not qualify for maternity leave or maternity leave with pay. If they are given the maternity leave or maternity leave with pay before they get to the 29th week, it is totally at the discretion of the employer. So it means that if the employer don't give them the money, they can't argue. If they don't give them the time, they cannot argue either. I hope that that provided some clarification, because I know a lot of people, you'd have said, no, but that is so wicked. I understand how people feel about it, but we have to still base our responses on what the law says. Daniel, how do you feel about that? Daniel, right?
Well, the law is the law, as you were saying earlier. We have to take the emotion out of it, and the most that we can do is expect I guess decency from our employers when we present certain situations to them, but it's not illegal for them to to follow the rule of the law, basically.
Right. Very well. All right. I'm seeing in the chat, John, thank you very much. I see you've uploaded some information fast. Well, the energetic group, John, you're on the ball.
Hi, good morning. I just want to ask a question, right?
Yes, go ahead.
Yeah. What if an employee applies for a job, right? Well,
yes,
somebody applies for a job, and they did not declare that they are pregnant. Some of them have even though they're pregnant for a couple of months, their belly is still small.
Yes.
How can we treat the maternity leave in that situation?
All right, John, you have preempted me, because why I normally say it? When people apply for a job, sometimes they're already pregnant and they don't know. Or sometimes they're so glad to get a job that they go and go celebrate. And here it is. Within 9 months, they're ready to have a child or less. What is your obligation as an employer? It might sound very or too frank, but I'm going to say it this way. John, you have absolutely no obligation to that worker. None. You might be surprised at what I'm saying. But as an employer, you have absolutely no obligation under the Maternity Leave Act. Why? Because it only chips in after the person has worked with you for a minimum of 52 weeks.
Okay.
Right. So anything that you do is strictly discretion. It therefore means that when the person is ready to go off on maternity leave, there is no guarantee that you have to take them back into employment. There is also no guarantee that there's no requirement rather that you have to pay them for the period of absence either, right? If you want to reconsider or consider taking them back after the period of maternity, that is totally your choice. The only thing I can say though, John, is that if the person has taken the job and they're not performing well, you will have to go through a very careful process, because people may take a case against you to say that they have been terminated by you because they were pregnant, right? So that's the only caution that I would want to give to you, that while a woman is pregnant, if there can be a correlation between her termination and the fact that she's pregnant, that could cause you some issues. All right? Is that okay? A response, John?
Yeah. So you're saying that if while the person is working,
yes,
and they're pregnant, if you terminate them while they're pregnant, you could be liable for lawsuit or whatever. That's what you're saying?
I am saying that if they find a good enough case, yes.
Oh.
I've seen that.
But
And
once they go off,
I dealt with a case. It's still not concluded, so I won't speak too much about it. But at the time the person was terminated, she didn't declare to the organization that she was even pregnant, so they had no information about it.
Okay.
You see? So their attorneys right now is providing a defense in relation to that, because she's now claiming that at the time she was terminated, she was pregnant. But there is absolutely no evidence that the company would have known, and that the company had taken its decision to terminate her based on her pregnancy. You see, because people, when they find that the law is sympathetic to particular situations, sometimes they try to abuse it. And I believe that this company may be able to make out a very strong case based on what I've heard so far. But it is one of those cases that in conciliation, we were not able to bring about a resolution. So it is going to head to the labor court, the Industrial Disputes Tribunal. All right. So,
so if she goes off under 3 months, which we don't have any obligation, and we decide we're not taking her back, couldn't she say the same thing, that we took her because we didn't take her back because of her pregnancy?
So listen to what I'm saying carefully. She's not going to go off on any 3 months. Hold on, let me just back up. You're saying the same scenario where the person has not worked the 52 weeks?
Right.
Or if they have not worked 52 weeks, they're not going off on anything. They are just leaving the employment because they are going off. You're not giving them leave per se. It's not a period of leave.
Oh.
Because they don't have a permanent place in the structure. Unless you took them on, appointed them permanently, they would not have a right to return. So it's not vacation leave or anything. All right?
Okay, so if you appointed them permanently, that means you'd have to treat it.
That's the only time they have an obligation. Forget the maternity leave or maternity leave with pay. But in the case that John gave me, I would have presumed that the person just came on, didn't declare that she was pregnant, and here it is, she's going to have to go off before the period.
Right.
Period. So he would have absolutely no obligation to her. So when it's time for her to go off, based on the date that her doctor gives her, she would have to present that. She would go off. He would then decide whether she has to reapply for a job, or if he feels she was a good worker, he can choose to recall her, but he has absolutely no obligations on either side. Okay?
Okay.
All right. So I've been talking about the expected week of confinement. Oh, sorry. Yes, go ahead, my dear.
Good morning. I had my hand up waiting for my turn.
Morning. I wasn't looking at the hands. Pardon me.
I'm Tamika Becky, representing Caribbean Assurance Brokers Limited. First time here.
Hi, welcome, Tamika. Good to have you.
Yeah, man, interesting session so far. All right, so my question is in continuation to John's own. So for example, well, not for example, the person in question, right?
Yes.
Would the employer be in any trouble per se if it is that we offer the person a contract and then after which they declare that they were pregnant? Would the employer be at fault to rescind that contract? One, given the nature of the job, it would be sales oriented where that person has to be back and forth traversing. I mean, being have to travel and stuff like that.
Let me question you a little bit more. So you've given a 1-year contract, for argument's sake.
Yes.
And the person has just started, and the person comes to you within, say, 3 months to say that I am pregnant. Yes?
Yes.
Okay. All right. And you are saying that based on the fact that she's now pregnant at 3 months of the contract, she's telling you she's 5 months pregnant. So you know that she only has another 4 months before she goes off. So 7 months into your contract, she's going to go off on maternity leave. What happens? That's what you're asking me?
Yes.
What happens is that when she gets to the period that she is to go off, she would go off, but there's no guarantee of an extension of the contract or a renewal of the contract.
Okay.
All right?
Yeah, man. Thank you.
Okay. If within the period that she's there under the contract, she's not performing well, you have to be very careful, because the termination under those circumstances can really be questioned. All right?
Okay.
So I
thank
would
you.
probably move her to a less sensitive area or somewhere that she can manage better.
Okay. Thank you.
Okay. I know that security companies have this kind of issue because women sometimes take on the jobs, they don't even know they're pregnant, and it's difficult to have a security at the gate who is 7 months pregnant. You know, it's very difficult for the company. But what a lot of them do is probably to pull them back to other areas. So that's an option for the employer. And that's again a discretion. Ayana, I saw your hand go up.
Right. In keeping with some of the questions that have been asked, I know they're asking questions based on contract, etc. But what if the employee is a full-time employee, has worked the 52 weeks, and of course would be eligible for mat leave? Can you make a person redundant during a period such as that while they are pregnant?
No. You cannot make a person redundant. You cannot terminate them for any reason if it can be linked to their pregnancy.
All right.
And we're going to get into the how the redundancy treats if the person is on maternity leave and there's a redundancy exercise. So you'll see that come up soon on the slides.
Thank you.
Okay, no problem, Ayana. All right, so the expected week of confinement, we've been mentioning that quite a bit, and it's a week in which it is expected that her confinement will take place. But my friends, you know that the baby them no work with that sometimes. So question to you, if the baby comes before the expected week of confinement, when would the maternity leave start?
When the baby comes.
It will start when the baby comes, which is going to be before the expected week of confinement.
Yes, that's correct, right?
All right. So I'm going to ask another question. If the expected week of confinement is, all right, let me say expected date of confinement is today, the 23rd of, today's what, the 24th, sorry.
24th.
May one day behind time. The 24th, if it should start today, the 24th, and the mother goes off, but the baby is born on the 30th of January. What date will the maternity leave start?
When the lady goes.
Which is what?
Which is the 24th.
It would start today, the 24th, that she has gone.
Right.
It's the 24th.
Exactly. All right. I just want to be sure that we're on the same page. All right. Thank you. All right. So when we talk about the original contract of employment, remember we're saying that the person has to be permanent in the organization to benefit from this. So in relation to any worker who is absent from work.
I'm so sorry.
Yes.
I'm so sorry. Can you repeat the example that you just said a while ago, please? You're saying that once she goes off on the 24th, if she has the baby on the 26th, the mat leave would start on the 24th?
That's correct.
All right. Thank you.
All right. All right. So the original contract, when we speak about original contract and the right to return to work, means that the person has to be appointed, has to be a permanent worker, can't be a contract worker or anything like that. Okay? So in relation to any worker who is absent from work wholly or partly because of pregnancy or confinement, it means the contract under which she worked immediately before the beginning of her absence. So let me give you another example now. There is a patty shop, and this patty shop has a couple of locations. It has one in Halfway Tree, and it also has one in Ligony. She was employed to work in Halfway Tree. She went off on maternity leave with pay because she qualified. And 2 days prior to her return to work after maternity leave, she gets a letter to say that she should report. She's a cashier, and she should report as a cashier, not at Halfway Tree, but she should report as a cashier to Ligony. Is there anything wrong with that? Tasha Gay?
You're saying that she's supposed to report at Halfway Tree, but she gets a letter.
She normally works at Halfway Tree, but 2 days before she resumed duties, she got a letter from the HR to say she should report to work as a cashier, same position, at the Ligony branch.
I would say it all depends on the contract. If the contract states that the company has the right to change your location during your contract employment, then they may do so.
All right, let me take a pin on your response. Tasha Gay, you wanna contribute?
Hi, morning. I was gonna say something similar to what he just said. That based on the nature of the employment or the company, how they operate, then I wouldn't think there's anything wrong with that.
And that's the exact reason I asked that question, because there is something wrong with that. Remember, I was saying that in the labor laws, it is not based on our gut feeling or emotions. It's based on what the law says. Okay? So it is saying clearly that if she's away from work, whether wholly or partly, because of pregnancy or confinement, she is to return to her original contract, meaning the same location, same kind of job, same kind of conditions, hours of work, pay, all of that must be the same. You cannot say, boy, I'll send her up there. She should really, on paper, resume her original position. She can agree with you to go elsewhere, but if she doesn't, then you can't send her. All right?
Okay.
Anybody wanted to comment on that?
I think based on the little knowledge I have, it is stating that whatever condition she was previously employed in, work conditions, that it should remain the same upon her re-entry to work. So nothing should change as it relates to her pay, remuneration, benefits, and basic duties. All of that should be the same.
Even her location should not change.
Right. Okay.
And I know that there are a lot of people who say, but Ligony far from Halfway Tree, so what's the deal? And a lot of times we have this problem because the employer says, but I have the right to transfer workers. Yes, you may have the right to transfer, but not under this condition, okay? You have to allow the person to resume. After she resumes, you can do whatever it is that you will do normally as management, okay?
So,
someone is asking, Lorraine is asking if the slides will be shared. Yes, Lorraine, you'll get a copy of the summary presentation.
Question.
Yes, go ahead.
What about if the company works on shift, right? And the shift change.
Well, what I said is that her her hours of work should not change. So for instance, if she was already working on a shift system, then that's fine. But if she was never working on a shift system and now you want to put her on a shift, that is a difference in her terms and conditions.
Oh,
right?
all right. So we cannot really bend it or whatsoever.
If she normally worked, say, 40 hours per week, and you're now demanding that she works 60 hours, that's a change in her terms and conditions. If she normally worked 40 hours, and now you're saying, boy, things bad enough. We can't give 40 hours no more, we have to give 35. That is also a change in her terms and condition, and that is not correct. Okay?
Okay, thank you.
All right. All right, so this particular legislation sought to define who's a worker. And it says an individual of the female sex. Why, I mean, I know, it's like this thing, I anticipate a lot of things happen from, because you have people who are changing their identity these days and so. But what it is saying is that you have to be of the female sex. You can't be anything other than a female to access this one. So it doesn't acknowledge the gender differences in terms of the new genders. All right, so it says an individual of the female sex who has entered into or works under a contract with an employer, whether the contract is expressed or implied. And if it is expressed, whether it is oral or in writing, and whether it is a contract of service or of apprenticeship, and includes any such individuals employed in the service of the government, including the service in the JDF and the JCF, and the employer shall be construed accordingly. That's a mouthful. Why do we have this on the screen? One is to show that it's only female sex that qualify, no other derivations. The other thing it is saying is that even if you don't have a written paper called a contract, you will still qualify, because there are some persons who have never gotten a job letter, unfortunately, or have never gotten a contract. And remember, it's not all contracts are fixed term. Some are permanent contracts, okay, for permanent employment. What it also says importantly, and I want you to take note of this, is that it is whether the person is a contract of service, which is a worker, or of apprenticeship. Let me ask a question now at this time. And I'm gonna ask Adrian, you wanna answer? I'm gonna ask Adrian to give me a perspective, and Sophia. So here is a question. There is a young lady who was being trained as a medical doctor. There's a period that they have to go through where they're senior resident, they call them. And they work for about a year in the public hospital. But many times after they have done this period of internship, they are employed to the hospital. So this young lady, she was working at the university hospital as an intern, and then she was employed as a worker. She submitted to the hospital that she wanted to go on maternity leave, but that was within 4 months of her permanent employment. Is she qualified for maternity leave any at all?
I think so.
Why would you think so?
How long did she went on apprenticeship?
She did a year. She did a year. 4 months.
Been a year. Been a year of apprenticeship, right?
Yeah.
Yes. She was a year as an intern, yes.
Yeah, she is qualified.
And then 4 months into the job.
She is qualified. And I tell you something, for a very long time, the Junior Doctors Association had this big issue with the Ministry of Health because they were being told that they did not serve the qualifying period. And we were able to straighten this out some years ago, but it was a very vexed issue. So you're all right, because the period of apprenticeship, this is the only time in any law, the period of an apprenticeship counts as